Are you dealing with harassment from debt collectors? A debt collector's job is to pursue you until they convince you to find a way to pay your debt. Often, a debt collector's compensation is related to how much money that they can get you to pay. So it's probably no surprise that many debt collectors cross the line when it comes to the aggressive and tricky tactics that they will use to get you to pay. However, as a consumer, you do have rights when it comes to how your debt is handled. Let's take a look at some of these debt collection tactics and the options available to you to make the harassment stop. Hi, I'm David Candler Hicks of the Alliance Legal Group. We are a Florida-based law firm that focuses on helping clients deal with debt collectors. Would you like to learn more? Come join me. The Fair Debt Collection Practices Act, or FDCPA, is intended to ensure that debt collectors don't hassle individuals in debt. Often, even a single call from a debt collector can feel like harassment. So the FDCPA lays out rules to regulate what is and what is not allowed. Here are some tips to remember. You have a right to question or dispute the debt. If you don't believe you owe the debt, you can dispute it with the company. Whether you believe the debt is legitimate or not, you can always ask the debt collector to send verification by mail. Phone calls must stop until you receive the debt verification. Frequent harassing, annoying, or intimidating phone calls are not allowed. Debt collectors are not allowed to lie or use misleading statements about your debt or the debt collection process. Phone calls before 8 a.m. or after 9 p.m. are also not allowed. If you file for bankruptcy or hire an attorney, debt collectors may no longer contact you. All calls must be directed through your lawyer. Debt collectors cannot publicize your debts. The collector can't talk to anyone about your debt except you, your spouse, or your attorney. If they do so, it is illegal and you can sue them. The FDCPA applies only to third-party debt collectors, not to the original creditor. Florida has its own version of the FDCPA called the FCCPA, or the Florida Consumer Collection Practices Act. There are many similarities, but one of the biggest distinctions is that the collection entity does not have to be a third party. At Alliance Legal Group, we help clients dealing with harassing debt collectors to find options to exercise their rights and to get their financial lives back on track. We'd be happy to discuss the circumstances of your situation with you and help you find appropriate options. I'm David Candler Hicks. Hope you have a wonderful day.